Good evening, everyone. It is Wednesday, July the 2nd, 2014. You are watching / listening to episode 58 of the Skeptic Canary Show. I'm Tom Williamson from skepticcanary.com, and with me is David James.
Hello.
And our special guest this evening is Helen Dale. Helen, good evening.
Hello.
Now, Helen, you are a corporate lawyer currently practicing in Edinburgh. Is that correct?
Yes, that's correct.
Excellent. And you are dual qualified in English and Scottish law?
Yes, England and Scotland have different legal systems.
But one of the things we're going to talk about, before we talk about the differences between English and Scottish law, and I've read a little bit about them and I think they're fascinating, is people may have seen that on Monday, Twitter exploded with lots of people in the States tweeting about the case of Hobby Lobby. And myself being an ignorant Brit, I was a little bit confused as to what this meant. But Helen, from your corporate lawyer perspective, it is actually very, very interesting.
Well, the Hobby Lobby decision that was brought down on Monday, it was a very close ruling. It was in the Supreme Court of the United States, which I will from here on in abbreviate to SCOTUS, that brought down the decision, which is the Superior Court in the US. It's the equivalent of the House of Lords here, or now the Supreme Court of the UK, or SCUC, which also has a horrible name as well if you abbreviate it. They tend to use UKSC because it isn't so gross. And what the ruling was, it was very narrow, 5-4, 5 in the majority, 4 in the dissent. The reason superior courts have odd numbers of judges is for precisely this scenario. What the ruling was that a close corporation didn't have to comply with the contraceptive mandate of Obamacare, or the Affordable Care Act in the United States. Now, the basis for that was that a piece of legislation known as the Religious Freedom Restoration Act imputed to the corporate entity, in this case Hobby Lobby Inc., the religious views of its shareholders and directors, the Green family. And they are Christians. Interestingly, the judgment didn't say what sort of Christians they were, but they close on Sunday. They have, even though it costs them money, they have very traditional sort of Christian values, and one of which is an opposition to abortion. And they alleged, apparently unscientifically according to my medical friends, that 4 of the contraceptives provided under the insurance mandate with Obamacare were actually abortificants. Apparently they're not, but they believe that they are. And when you're dealing with religious belief, as it is worked through in the United States Constitution and the First Amendment, you have to accept it for what it is, even if they're saying things like the moon is made of green cheese.
Now, I should say that the whole Hobby Lobby decision takes in a huge number of areas, so contraception, healthcare, employment law. So if you'd like to have your say in any of the things we talk about, you can get in touch via Twitter. I'm at Skeptic Canary, or you can email tom@skepticcanary.com. And one other thing we do need to do, Helen, because you are a practicing lawyer, we do need a little bit of a legal disclaimer, I believe.
Yes, yes. It probably doesn't matter very much because I'm talking about law in the United States, but as should be reasonably obvious, I am not a qualified lawyer in the United States, and so therefore anything I do is literally just been based on me sitting around the office because we've not been so busy for the last couple of days doing research on this. And of course I can't, because I'm making general commentary on the law, nothing that I say can be taken to be legal advice. If you want legal advice, you have to engage me as a lawyer and pay a fee. unfortunately. Yes, I insert lawyer jokes now about blood-sucking lawyers. But nothing that I say here can be considered legal advice, although it's very unlikely to be, because I'll mainly be talking about the law in the United States.
Okay, okay. I think the first thing to talk about is the difference between how healthcare is provided here in the UK and over in the States. So in the States, why do American employers pay for their employees' health insurance?
Well, this is a very peculiar bit of American healthcare, and it is the thing that makes it very bad compared to everybody else's healthcare. And it's important to caveat this at the beginning by pointing out you can have other countries that have completely privatized healthcare systems, like Singapore, for example, or partly privatized healthcare systems like Japan, as well as single-payer healthcare systems like Britain or Australia or France, all of which, whether they are public or private, and their healthcare systems are much, much better than that of the United States. And the reason they're much better is because health insurance is never provided by employers to employees. So that's the first bit of it. The next bit of it is the reason this very, very stupid practice is engaged in the US is because during the Second World War, the US government, as a result of typically inflation and attempts to hold inflation down during a wartime economy, which can produce an artificial economic boom, fixed wages. It was not possible to give people a pay increase, even if they deserved it. So the way that employers would try to induce people to work for them when they couldn't give them a pay increase was to give them fringe benefits, I think is probably the best way of describing it. And one of those fringe benefits was healthcare, health insurance. And so the Americans developed a habit in the last 2 to 3 years of the Second World War of relying on their employer for healthcare and health insurance. And of course, during the wartime economy, they had full employment. Then, after the war, very foolishly, the Eisenhower administration decided to make healthcare insurance a tax deduction for American employers, concreting the system into place and making it, because it's a tax deduction under the US tax code, making it very difficult for any subsequent administration of any political stripe, Democrat or Republican, even when they wanted to change it. I mean, for example, Reagan wanted to change it and found it just impossible, of any political stripe to change the system. So you've got two things going on. You've got the provision of health insurance through employers for which a tax deduction is provided. You've got no actual operating healthcare market. Americans are always shocked if they see a Bupa office in the high street over here. So you don't even have a functioning private market in the US. And the equivalent of the NHS in the US is actually Medicare and Medicaid, which is for the elderly and the very poor. And it was actually George Bush Jr. who made the provision for the elderly a sort of quasi-single payer system, but not really. It's a very, very strange arrangement. But the worst thing about the American system is the provision through your place of employment, because it means you're not covered if you don't have a job or if you're self-employed. There is no proper market if you're self-employed to go and buy healthcare insurance, although the Obamacare exchanges were meant to fix that. And you've then got the situation where, because it's fragmented, the market is so fragmented, everything is very expensive. Mm-hmm. So it is a failure from root and branch. You cannot imagine a worse run healthcare system.
Well, if you could even call it a system, really.
No, it's not.
It just seems so fragmented. Okay. Excuse me. Okay. Well, in regards to this ruling, the US Supreme Court have decided that Hobby Lobby, based on their that sounds so weird saying that, Hobby Lobby. Anyway.
Well, one thing that did seem to come out in the judgment was I don't think that the 9 justices, regardless of which way they ruled, were particularly happy with saying Hobby Lobby repeatedly either. I mean,
Okay.
the difficulty in Scotland
You could
is
always say,
both hobby and
say,
hobby rhyme with something very rude, and so I've got to be quite careful when I say it.
Right. Yes, absolutely. Okay. What was that, David? David.
I say you could always say, was it Conestoga Wood?
Oh yes, well there were other parties.
Okay. Well,
Yes.
Yeah, it was Conestoga Woods Specialties, who were Mennonites, weren't they?
And Martell,
It's a Mennonite.
but Martell is a subsidiary of Hobby Lobby.
Yeah.
Oh, I see. I see.
Yeah.
Okay. So Hobby Lobby, being a Christian company, have decided that they don't have to pay for their employees' contraception.
Yes, or certain types of contraception, on the basis, this is where it gets very difficult to explain, on the basis that they believe it's an abortificant.
Yes.
But the scientific evidence is that it is not an abortificant, but they believe it is an abortificant. And the court, both the majority and the dissent, had to phrase this extraordinarily carefully, because it is akin to believing that the moon is made of green cheese, or that the Loch Ness Monster exists. I mean, it's very difficult to sort of get it across, but because of the First Amendment in the United States, and we have it to a lesser extent with Article 9 of the European Convention of Human Rights, when you protect conscience, you have to protect things that are nonsense. And this is nonsense. But when you give people freedom of conscience, they're allowed to believe in nonsense. I mean, this is the difficulty, but that's the way the system works in developed countries, or otherwise, you'd be saying, well, that's nonsense, you're not allowed to believe that. And then that's what actually led to the wars of religion back in the sort of 17th century, so we don't want to go there again, going around telling everybody what they believe is nonsense.
Well,
it's the difference, isn't it? You can believe what you want, you just don't have the right to make other people follow that belief.
Well, yes, that's the understanding, the tradition, the liberal bargain is that you can believe what you like, but you can't make other people, you can't impose that belief on others. That laws should be facially neutral.
So in the variations of contraception that Hobby Lobby object to, I mean, for me, it's just very strange, this notion that you would expect your employers to pay for your contraception anyway.
Yes.
Because certainly in my experience, and I'm pretty sure this has been the case with the NHS for a long time, is that the NHS provides contraception. If you want condoms, you can go to a GP's office and get them for free. And the same with pretty much all other methods of contraception. And for me, that seems completely right. If you've got a state-run healthcare system, that contraception ideally should be a fairly basic right. So that should be providing it. I just find it very, very strange. But
it's very difficult because it is the only country in the world where this system obtains, which is where your healthcare is provided through your employer and not through either the state or through an insurance company with which you have contracted on your own behalf. It's a very odd thing, and it is very difficult to get across to people who live in other systems, whether they are public or private. It's just a really, it's very difficult for me to get my head around as well. I mean, I actually have bupa cover through my firm, and I found that very odd to be provided. But I've always, by the same token, if an employer offers health insurance in Britain, it is in addition to anything that I may have already privately arranged myself, or the NHS. Or in Australia, where I grew up, it was the same thing. It was either in addition to something that I'd organised myself, or in addition to Medicare, which is the Australian system. And it is conceptually very strange. And that's all I can really say for people outside the US.
So this decision by the Supreme Court, they reference the Religious Freedom Act.
Yes.
So what is this act?
Okay, well, basically, what the Religious Freedom Restoration Act, which was passed in 1993, does is provides far more protection, and this is a direct quote from Alito, who wrote the judgment for the majority. By enacting RFRA, Congress went far beyond what this court has held is constitutionally required, and that's with the requirement to protect religious freedom of conscience. So this is actually a decision that is not about the First Amendment. It's a decision that is about statutory interpretation. This particular statute gives exaggerated protection to religious belief in ways that both the majority and the minority made quite smart remarks about, along the lines of, Alito saying, I do not wish to inquire into the wisdom of what Congress is doing at this point, and things like that. And I will get on to that, why it could be very, very destructive later. But what the Religious Freedom Restoration Act does is Section 1A provides that government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability, unless government demonstrates that application of the burden to the person, 1, is in furtherance of a compelling governmental interest, and 2, is the least restrictive means of furthering that compelling governmental interest. Now, by 9-0, all the justices accepted that the provision of low-cost contraception under the Affordable Care Act was in furtherance of a compelling government interest. Where it failed for 5 of them was the second part, was, is the least restrictive means of furthering that compelling governmental interest. Now, there's 2 things going on here. 1, when in Section 1A, when the court ruled on person, they gave it its legal meaning, which means it takes in both natural and juridical persons. And 2, when they were talking about the least restrictive means of furthering that compelling governmental interest, very amusingly, and this is very amusingly, they gave the Congress of the United States 2 ways of solving this particular problem. First, they said you could just force the insurance companies to pay up without charging a copay to the woman who wants one of these 4 methods. And that is what other aspects of the Affordable Care Act does with charities, religious charities, for example. But they also, and this is Alito in the majority, also said this, and all my British listeners and Australian listeners can laugh now. The most straightforward way of doing this would be for the government to assume the cost of providing the 4 contraceptives at issue to any woman who are unable to obtain them under their health insurance policies due to their employer's religious objections. That's reasonably obvious. I'll read it again. The most straightforward way of doing this would be for the government to assume the cost of providing the 4 contraceptives at issue to any woman who are unable to obtain them under their health insurance policies due to their employer's religious objections, which of course is single payer. It's just a single payer for a narrow area of contraception. But that's what that is. Hearing that coming out of an American justice's mouth is just quite extraordinary.
Yeah, yeah. So they're saying that they're saying that the employer should want to pay for the contraception, but if they don't, then the state will.
Or an insurance company, depending on who gets tapped to pay.
Right, okay. Right. That's
now, a little bit of background on this Religious Freedom Restoration Act is worth giving here. 1, it's very bad law. And the reason it's bad law is it provides exaggerated protection to religious belief at the expense of all other kinds of belief. So, for example, if you were a secular organisation, you couldn't claim on the basis of very, very sincere beliefs that everybody should wear a Star Trek red shirt to work every Monday. Could be quite dangerous.
Very dangerous.
So you can't do that if you're a secular, a Trek geek or anything. You can't do that. It could cause difficulties. So it's only for religious beliefs. And it's a very telling criticism that it actually was generated by quite a noble but very misguided belief. A lot of people, when they criticise religion, they only criticise the big ones, the big powerful ones, like Islam or Christianity or occasionally Judaism, but not very often. Now, the Religious Freedom Restoration Act was enacted in response to the prosecution of 2 Native Americans who used peyote, I don't know how you say it, but I presume it's peyote, which is a hallucinogen, in a religious ceremony. And they were nicked for it because of the war on drugs. And they then pleaded their religion and said that this was in violation of the Establishment Clause of the US Constitution, and they lost. They lost badly. I think one of them went to jail. And then they couldn't get unemployment benefits because they'd been sacked for a valid reason and all of these kinds of things. So Congress, a bipartisan Congress, enacted the Religious Freedom Restoration Act to protect any religious belief. And it really is any religious belief. And I do believe that the most important part of the dissent is Justice Ginsburg's point, with which 3 other justices concurred, is that you are now going to get floodgates litigation as every other religious group tries it on. Now, the majority tried to head this off at the pass and tried to say, oh, it won't apply to vaccinations and it won't apply to blood transfusions, but it's very clear they're making it up. It was what in the legal profession is described as obiter dicta. It wasn't a ruling on point, it was said only by the way, if that's what obiter dicta means. So, and Justice Ginsburg came up with a few thoughts that she thought were possibilities that could happen in the future. The Scientologists objecting to psychiatric care and antidepressants. Jehovah's Witnesses objecting to coverage for blood transfusions. Muslims objecting to anything involving pork. And Christian Scientists objecting to vaccinations. All perfectly, sincerely held religious beliefs. So, I mean, the moral of the story is, just because a group of people believe in a religious tradition that's kind of cute and nice, you know, Native Americans, magic mushrooms, peace, love, mung beans, poor oppressed brown people, you know, we've got to look after them. No, you don't. Nonsense is nonsense. You either protect all of it, which is where this piece of legislation leads, or you protect none of it. And you can't give the poor, the vulnerable, the disadvantaged a special pass for nonsense. And that's exactly what this legislation was enacted to achieve, was to give Native Americans special pass for nonsense. Now, of course, I'm leaving aside the war on drugs, which is nonsense, an even bigger lot of nonsense than this, but considering the law of the land at the time. So that's a little bit of background on that.
Okay. Well, excuse me. Well, the next question I wanted to ask was, couldn't Hobby Lobby do what they're doing in another way? I mean, do they have to, do they have to provide contraception in the through health insurance?
Well, the difficulty you've got is because in the United States, health insurance is provided through an employer, and under the Affordable Care Act, if you have more than 50 employees, you have to provide it, and Hobby Lobby would be confronted with very steep fines if they failed to comply, which is one of the reasons why they challenged it. But, I mean, to get back to sort of my professional practice area, the reason they got this ruling is because they're a special type of corporation. They're what Americans describe as a close corporation or a closed corporation. Mm. And yes, I know that means nothing to British people.
Yeah,
the best way of putting it in the UK, in a UK context, is a family company or a one-man company is probably one way of describing it.
A small to medium enterprise, perhaps?
No, not even an SME.
But that's
a closed
what's meant by closely held, yeah?
Yes, closely held.
Yeah.
An SME can have many, many shareholders, even though it's still a private limited company. I mean, I act for SMEs that have 100 shareholders, but they're still private companies.
I mean, up until recently, Sainsbury's in the UK was still family owned, and it would fall into the category of closely held, even though it's
yes. Oh, Heinz does in the US.
Company, Heinz.
And yeah, and
Oh, I
Hot
see.
Dog is quite large. They have a decent turnover. I think it's something like $30 billion US. No, it's a large company, but it is owned by a single family, and they all agree. Now, what people don't understand is when they imagine a corporation in their heads, when they think of corporations, they think of the public ones, the ones that are traded on the stock exchange in London. They think of BP or Amazon or Nestle. And that's actually very unwise to think of those in those terms, because those are the minority of corporations. Most corporations are private corporations. They're private limited corporations. In the UK, the abbreviation is LTD or limited. In the US, they've got different abbreviations. Now, a closely held one, though, is when you've got the family or one individual holding all the shares and all the positions on the board of directors. Now, I recognise that my definition here is probably a bit more precise than the American one. I noticed that even the Supreme Court, when I was reading both the majority and the dissent, their definitions of what I would consider a closely held corporation were woolly, and if I drafted them into a document, the managing partner would have a piece of me. But in Britain, they mean held by a family where the directors are all in agreement. And traditionally, and this is where there's a very large difference between the corporations law of the United Kingdom and the corporations law of the US, it's very important to understand that even if you set yourself up in business and then incorporate, and it's just you and you hold all the shares and you are the sole director, the company is not you and is not to be identified with you. The company has its own personality. The company is a juridical person. You are a natural person.
Yep.
Mm.
Now, this can be very, very difficult to get through to people, and I have seen this with clients. I mean, an investor comes along and gives them hundreds of thousands of pounds for their to invest in the company. Says, "Oh, this is a good company. I think you're going to be a very successful startup," you know, so on and so forth. And I mean, I've had the experience of someone in my offices going, "Oh, I've got £500,000 now," and then the lawyers have to very quietly sit them down and go, "No, you don't. The company has £500,000, not you. And if you stick your paw in it, that's breach of director's duties."
Okay. This always confuses me, how a corporation can be its own person. So it's not say the sum of the wills of the directors. It is its own distinct legal entity. Is that right?
Yes, that's right. It's a juridical person. It's a legal entity. It's separate from its owners and it's separate from its management. And one of the things it typically does, although not in a closely held corporation, one of the things it typically tries to do is separate ownership and management, although it is very common to see directors rewarded with large amounts of stock in the company. That can be dangerous, though. I mean, that actually helped to precipitate some of the problems at Enron, for example. You can create problems with corporate governance. But in the UK, the reason why we have a very sharp division between the corporate entity and the individual behind it is because we believe the corporate entity largely exists, in fact, only exists really here to make money. That's what it's there for. And it is to act as a shield for the individual behind it, because what it does is it limits that individual's liability to the amount of money that they have put into the company. Now, the reason that's important is before the invention of the limited liability corporation with a separate legal personality, whilst we had separate legal personality, we didn't have the limited liability. Now, what limited liability does is it means that if your company goes bust, you don't lose your house. It's really very simple. That's what it's there for. And what it particularly allows is a person who doesn't have very much money or has some money, not enough to buy a whole company, but an opportunity to invest. So it's a very democratic institution, the limited liability corporation. It lets Joe and Josephine Average be investors. And it immensely broadened the base of capitalism when it was developed in the 19th century.
Mm-hmm.
Before then, anybody who wanted to invest, even if they had a bit of saving and an opportunity to do well in the future, they couldn't. Because if the company, the corporate entity, ran out of money, the creditors could pursue them to the last penny. And that's it. So that is why the limited liability corporation was developed. However, the way to make it work was to always ensure that the individual who set up the corporation was seen as a separate person from the corporation itself. Now, my problem as a corporate lawyer with the Hobby Lobby decision, it's an awful name, isn't it, is that it pierces the corporate veil. That is, it imputes the characteristics of the owners of the corporation to the corporation itself, which in the United Kingdom, Australia, Canada, and the rest of the British Commonwealth, you must never do. It is one of the least litigated areas of law in this country. We do not like you to pierce the corporate veil. It is there for a very good reason. It is to stop Joe and Josephine Average from losing their house. And we don't want any other characteristics dragged across and imputed to the company, or in the other direction either. If the company is engaging in fraudulent behaviour, that doesn't necessarily mean all the shareholders are. It's probably the directors, and so on and so forth. You have to keep the entities separate. Okay. However, when I was doing research on this yesterday, on this wonderful software program called PLC, Practical Law Company, which is a thing of wonder and glory, which was developed originally in Britain, and they're now using it in the US as well, is that by contrast with the UK, the most litigated area of law in the United States concerns piercing the veil of incorporation. It is much easier in America to dive behind the corporate veil for whatever reason, whether it's the kind of thing that's happened in this Hobby Lobby case or whether it's happened elsewhere, and then get at either the shareholders or the directors, typically the shareholders.
Okay, so when you say the corporate veil, is that legal speak for a sort of barrier, if you like, between the corporation and the directors and shareholders? Is that right?
Yes. Yes, it's probably best in the case of closely held corporations, it's probably best to collapse the two in together, even though it's a bit improper in the context of the law of corporations. So what you've got is a situation where that division between the natural person and then the juridical person of the company is swept aside, and that's called piercing the corporate veil or rending the corporate veil, depending on the jurisdiction. That's the cutting the corporate veil. That's the expression that is used, because what it means is to go behind the shield of incorporation that protects the persons, protects them from being made liable for the company's debts if it becomes insolvent, if it goes bust, is to go behind it for whatever reason. And I have to say the Hobby Lobby reason is a very odd one, but there are plenty of other less odd examples, and it's probably worth actually reading the judgment, because the US court, the majority, gives a great string of them, you know, where people have gone behind the veil of incorporation in a way that I find shocking as a British corporate lawyer. Yeah, and I say British advisedly because the law of corporations is reserved to Westminster, so the law is the same in Scotland and in England with relatively minor differences. And I find it quite shocking because we just don't do that here. That's not the way the system works.
Okay, but who decides if a company has, you know, has morals, and such as the Hobby Lobby decision, and who has the right to say what those morals are?
Well, you see, you're thinking like a Briton, which is, I mean, they're one of the witty one-liners that is often taught to you when you first do the law of company law at university. That goes back to one of the great English Lord Chancellors, Lord Chancellor Thurlow. in the 18th century is a corporation has no conscience. It has no body to be kicked. It has no soul to damn. And that is very much the traditional British understanding of it. Weirdly enough, the British understanding, the one that's gone out to the Commonwealth, is a much more intensely capitalist and mercantile. It recognises that the corporation is there to democratise capitalism, to make it easier for the little man to invest and to be given an opportunity to participate in the market. And it's really a vehicle for making money. And if you don't want to make money, or you want to do something else, you want to further your religious beliefs, or so on and so forth, I mean, the law in the UK is capacious. It gives you other entities, and when you go to law school, you will do a subject on entity law, by which you can do all sorts of things that aren't about making money, or are only about making money in certain contexts, or about achieving certain purposes, or are only about investments, or about running your business in a particular way. We have all these different kinds of business entities, and that business need not be for profit. And if you want to use your corporation to further your religious belief, and you come to a law firm like mine, you're very likely to be asked by the lawyer talking to you, have you thought of a charitable trust? Have you thought of a company limited by guarantee? Have you thought of a Roman mutual? Have you thought of a limited partnership, a limited liability partnership, or an 1890 partnership under the Partnership Act 1890? Have you thought of a community interest corporation? It's just, you know, there are all these other ways you can achieve exactly what you want if you want to further religion. And that's a charity. That falls under one of the classic heads of charity. The promotion of religion is a charitable purpose.
Ooh, well, as a committed,
law.
Yeah, I know. But as a committed feminist, that's always so galling to hear about. I want to set up a charity. What do you want to do with that charity? I want to spread my religion. Fine, do it.
Well, yes, you do realise, of course, the reason we have the charitable heads we do is because the legislation was passed in 1601. Yeah. It's called the Statute of Elizabeth, and it established 4 heads of charity: the relief of poverty, the promotion of education, the promotion of religion, and all other charitable trusts recognised by law, including animals and locality, but they must be for the benefit of the community. And the 4th one is the way they drag in sort of things like sports clubs and things like that. And interestingly enough, the British Humanist Society now falls under the promotion of religion head.
I know. It's
this is what happens when the law was written in 1601.
Mm. Oh, absolutely. And also, whenever I talk to any American atheist, they'll always bring up the issue of churches not paying taxes. Much
worse in the United States than here. Whilst the promotion of religion falls under the Statute of Elizabeth as an entirely legitimate charitable purpose, it's much more tightly constrained by the Charities Commission in England and OSCR, the Scottish charity regulator, up here. In the United States, I think it's probably fair to say that their law of charities is loose, badly run, fragmented, and it allows people to get away with things that you couldn't do in either England or Scotland. I will actually give you a secular example rather than a religious one, but it illustrates the point. PETA, People for the Ethical Treatment of Animals, in the US has got charitable status. It has continually failed to achieve the same over here, principally because they let too many animals die at their shelters. So it won't drag under the 4th head, which is for which includes animals, like the RSPCA.
Okay.
American charity law is also in need of reform. In a way that else probably isn't.
Okay. One of the things I definitely wanted to talk about at the start of the show, we've got about 20 minutes left, so I really want to talk about the difference between English and Scottish law, because there are quite a few key differences that I find fascinating. I mean, the first one I remember you speaking about at QED is in England, if you're charged with a crime that goes to trial, you can be found guilty or not guilty. But in Scotland, there's
3 verdicts.
There's also not proven. Is that right?
Not proven, yes.
Yeah,
Okay.
I remember you from QED now, Helen. I'm sorry.
So does that does that have implications for double jeopardy?
It used to, but it does no longer because of Article 6 of the European Convention of Human Rights. But it did used to. It used to be a way of hanging a sort of Damocles over someone's head, but it doesn't anymore.
Right.
It works. It works in concert with the much larger Scottish jury. Scottish criminal jury is 15, and the ruling is made by simple majority. And in order to prevent, as a prophylactic against wrongful convictions, with a simple majority, because it tends to be in England, they either have to be 11-1 or 10-2. A lot of common law jurisdictions, Australia, for example, you have to have all of them to agree, which is why, in a difficult case, sometimes the only thing that is hung is the jury. So what you've got is a way of giving the jury a get-out in Scotland when you've got a simple majority verdict out of 15, is that they can fall back on not proven, which is a way of publicly saying to the accused, sometimes called the panel in Scotland, publicly saying to them, look, we think you did it, and it's only because the Procurator Fiscal has put together a crap case that we're letting you walk out of the front of the building. But there is no doubt that these days, if the jury rules not guilty or not proven, in both cases you get to go home, and as my criminal law tutor up here in Edinburgh used to say, and have a cup of tea.
So practically these days, not proven and not guilty essentially mean the same thing?
The effect is essentially the same, yes.
Right, okay. Because I always thought that was going to be interesting for the idea of double jeopardy, because just make sure I've got the right idea here. If you're accused, you go to trial and you're found not guilty,
yes,
you then can't be tried again. Even
yes. In some respects, double jeopardy is a bad way of putting it. The Scots law, which is taken from Roman law, because the Romans had the same concept, is ne bis in idem, which means literally not twice for the same thing, or not twice in the same place, which probably captures it more idiomatically. And that's where you have a person who has already been put to the trial and found not guilty and told that they can go home. But the big thing you must remember is a finding of not guilty does not mean that the person is innocent. A finding of not guilty means that the Crown failed to discharge the onus. And that's the sort of crucial point to always keep in your head, which is why you have to be very careful and around the reporting, for example, of sexual offences and so on and so forth, because they're very hard to prove. But the difficulty is, just because you've got a not guilty finding, all it means is that the evidential onus has not been discharged. It doesn't mean that the person is as pure as the driven snow or a member of the sainted multitude or anything like that. And one of the sort of rules of it, exceptions to the rules of evidence, generally you're not allowed to, certainly in Scotland, you're not allowed to bring in previous convictions. However, what will happen though, if someone has been up on 3 rape charges and been acquitted for all 3 of them, and then the Crown's got a very strong case for the 4th one, is what you will sometimes get is discussion of the previous trials, but not convictions, but trials, to produce what is evidence of a pattern of behaviour, course of conduct, similar fact evidence, basically. It was done in the Ralph Harris case, where there was information adduced from witnesses who were outside of the jurisdiction, so he could not be brought to trial for those crimes. But because they were independent of each other, those witnesses, and none of them knew each other, it provided the Crown with very, very powerful corroboration.
Okay. So yeah. So on a very, very basic level, that's why it's called not guilty rather than innocent.
Innocent. Yes.
And
Whilst we have the presumption of innocence, the finding is not guilty.
right. Okay. So every time you see a news report that, say, I don't know, Dave Lee Travis walks free from court, that doesn't mean he's innocent. That just means that he wasn't found guilty at the time.
Now, very often it may well mean that someone is, in fact, innocent, but that's not the legal effect. The legal effect that the Crown has failed to discharge the onus.
Okay. Yeah, I'm almost worried about what I say now because in the back of my head, because skeptics talk about getting sued all the time, I'm thinking, God, I really don't want to be sued by Dave Lee Travis. But I really don't think that's going to happen.
No, I would love it if you got sued by David Lee Travis.
Very careful.
Okay. The other...
Yeah, I mean, a not guilty verdict leaves the presumption of innocence in place.
Yes.
Basically. So you can't... Because someone is found not guilty, doesn't mean that they are innocent, but the presumption is that they are.
Yes.
And you can't infer guilt by a not guilty verdict.
Verdict, yes.
This is
the easiest way of looking at it, Tom.
Okay, fair enough.
And don't mention David Lee Travis again, then we're fine.
Right, okay. Okay. Or anyone involved in Operation U-Tree. Fair enough.
That's just a train wreck. It's just, the awfulness.
Oh, it is.
It's just this horrible kind of putrid yuckiness that's...
Yeah,
it's really
it's sort of so many childhoods ruined in so many ways. I mean,
yes. Obviously and most dramatically the childhood of the victims.
Well, yes, obviously.
But I mean, yes, the description that I've used, and also a friend of mine in the Edinburgh Skeptics, Ashley Price, has used, is with Harris in particular, is a kick in the childhood.
Yeah, definitely.
Really, in the childhood.
I remember Rolf's cartoon part of everything. Yeah. Okay. One other Scottish legal term, which you talked about, which I found very interesting, being a football fan, is in Rexa, which I believe is
banter. Banter, Scottish banter. It's in Rexa just means in fury or in anger in Latin, and it's one of the differences between the Scots law of defamation and the English law of libel and slander. What in Rexa is that if you're very rude to someone in England, you're quite likely to still be able to finish up, if it's combined with an untruth, to finish up facing a defamation suit. In Scotland, if you're very, very rude to someone in the context of a heated argument, then you're much, much more likely to find that any claim in defamation will fail. Now, I should have said libel and slander, and for England and Wales, this is what happens when you haven't done any English law for a while. You've only been practicing in Scotland for ages and ages. But yes, that's a difference, and in certain respects, although there are problems, and likewise in Scotland there need to be reforms to the Scots law of defamation, there are certain areas where they probably don't need reform, and the fact that people can just sort of shoot their mouth off a bit, off the blue, in a big argument, or there's what the Scots call a stooshy, is probably a good thing, because otherwise you would never hear the end of it. And this is how London just became the libel and slander capital of the world. Well, libel mainly because these days slander's relatively rare, but certainly the libel capital of the world is because every single little thing can be taken, to a ridiculous extent.
Yeah, and of course nowadays we have Twitter, and people have gone to jail for tweets. We had the famous Twitter joke trial.
Oh, the man about the Robin Hood Airport.
Robin Hood Airport, yeah.
It's the man with the Robin Hood Airport. That was just ridiculous. I mean, and that is also, that's not just, you need to stick the blame where it sits. It's not just silly laws of libel and defamation in that case. It's also the war on terror, and everybody swallowing stupid pills as a result of the war on terror as well.
I think we just need to briefly recap what the Twitter joke trial was. There was a guy called Paul Chambers, I think it was, and he just missed a flight from Robin Hood Airport or something like that. Robin Hood Airport.
Where is Robin Hood Airport?
It's somewhere near Nottingham. And,
it's a provincial airport.
Yeah. And he said on Twitter, right, they've got an hour to get their SH1T together, or I'm going to go and blow the place sky high or something.
Yeah.
You know, something you might say if you've missed a plane or
you're about to miss the plane.
Yeah. You get angry, you tweet something. I'm sure we've all done it.
Yeah.
But
I haven't. But then I'm a lawyer and I'm practicing where I'm about. So.
Yes.
I mean, on a personal level, it feels a bit like when they ask you at the security desk, "Did you pack your own bags? Have you got anything you haven't got in you? Sorry, have you got anything in your bags or in you that you shouldn't have, I suppose?" And you're pissed off, so you say, "Yeah, I've got a bomb in my bag." You know what's going to happen.
Yeah.
I mean, I think the ruling was correct in this case, in the Robin Hood, in the Twitter joke trial. But you think to yourself, there's just some things you just don't say. Threatening to blow up airports in any context is one of them. It's just.
But yes, it is. I do think we've got the problem in our culture at the moment where everybody wants to be secure.
Mm-hmm.
So they put pressure on governments and police forces and prosecution services to enhance our security. But by the same token, people don't like being stopped and searched by the police. People really don't like being patted down at airports, and the American ones are dreadful. I mean, they really needed to take some lessons off the Israelis, who at least know how to do it. You know, that's a country that's under serious security threat, and yet the Israelis somehow managed to do it reasonably politely. I'm always very impressed by it. And it's partly because they're completely frank. Israeli customs, they will say, we are concerned because we have had bombs go off in our airports before, and we don't want it to happen again. Whereas everyone else tries to engage in all this silly faux politeness, and it just makes it worse, I think. So that's the difficulty. Is everybody wants to be more secure or wants X, Y, Z from the government or from a company or whatever, but then they don't actually want to go through what that necessarily entails.
Yeah, the realities of it, yeah.
Mm-hmm. Yeah, absolutely.
I love the idea of a red mist law.
Sorry?
I love the idea of a red mist law. Sorry, just going back. I like the idea of just going absolutely ballistic at someone and as part of a heated debate, and then it being okay. I can think of a few people I'd like to do that with.
You'll have to have your arguments with them north of the border.
Yeah, that's right. Well, there's a few north of the border.
Steady.
Not allowed to mention indie ref.
Yeah. Let's not get into mentioning names. Not when we've got 5 minutes to go. Yeah. Yeah. Well, we're coming up to the last 5 minutes of the show. So one thing that I had planned to talk a little bit about was libel law, and if you're a skeptic and you are trying to do something about, say, What Doctors Don't Tell You, that magazine, available in the Rice Lane Sainsbury's, I found out this morning.
Working on it, Tom.
Good. I mean, you do have to be careful about what you say. I mean, are there any, really basic, obvious rules that you could put together for engaging with alternative medicine practitioners, that sort of thing?
Aware of, and this is try not to use words that actually have a legal meaning.
Yes.
And the big and obvious one is fraud.
Mm-hmm.
If you call someone a fraud, because if you're just going around and having a bit of chat at Tesco's and saying that somebody is a fraud, you don't realise that it actually has legal significance, and it's an extremely serious allegation, because whilst it's a civil matter, it's one that the courts have always traditionally viewed as this sort of strange intermediate point in between a civil claim and a criminal claim, and because of course there is such a possibility as criminal behaviour that is fraudulent too, like when you defraud HMRC and that kind of thing. And so that's probably the best thing, is avoid words of actual legal significance. And the one that I've noticed that skeptics can get a bit free with is fraud. And the big thing to remember, that the legal definition of fraud is not just telling a lie that deceives someone. It has to damage. So if you're alleging that a magazine, in this case, is telling a lie that deceives someone, which is the layman's understanding of fraud, the legal understanding of fraud is that it caused damage to a named individual, to a group of individuals, and damage that can be measured, because the award is traditionally remedied by the award of damages. So that's probably the best basic advice, and that is the word that I notice that people use.
Yes, yes.
And I know it's enormously tempting, and the thing is, but it's probably better to look for actual instances of damage and enumerate them, and not so much with I mean, I don't know enough about that magazine to be able to say, but when you're, say, dealing with anti-vaxxers, I mean, the damage that anti-vax causes is measurable, and the reason it's measurable is because we've got very precise ways of calibrating things like herd immunity. Just because someone says a load of bunkum doesn't mean they're a fraud. And I mean, the first piece I wrote last year for the Skeptic magazine, I tried to explain to skeptics in the context of the Sally Morgan ruling that all the things that were imputed or have been imputed by skeptics to Sally Morgan can also be imputed to organised religion. And it seems that only the organised religion can be given a degree of a pass simply because lots more people support it, believe it. Mm-hmm. But it's got many of the same qualities. You've got the same sorts of claims: prophetic claims, claims about being able to see the future or speaking different languages, and all of this kind of thing. So it becomes enormously difficult to live in a society with a plurality of beliefs if you get someone who believes in something a bit odd and then you call them a fraud. Okay. I mean, one quick thing that I'd like to add. So for a fraud, you have to be deliberately deceptive. You can't just be wrong. No, if you're wrong, and particularly if it induces someone to enter a contract, that's innocent misrepresentation. If you're wrong and you're carelessly wrong, that's negligent misrepresentation. If you tell a lie, that's fraudulent misrepresentation. Okay. And that's in the context of inducing people to enter contracts. Right. Okay. Well, on that, it's 8 o'clock. I'm afraid we've got to wrap up the show. Helen, we always like to. I hope that was useful. Yes, certainly was. Very, very interesting. Very informative. Yep. But one thing we always do at the end of the show is just give our guests the opportunity to plug anything they'd like to plug. So any appearances or any useful legal websites, anything like that, you have the floor. No, absolutely. I mean, well, I'm on Twitter at @Helen Dale. If you're interested in sort of legally things that I put out, please feel free to follow me. But it's not just my name. It is @ and then an underline and then Helen Dale, all one word, capital H, capital D. So if you're interested in sort of vaguely legally type things, I try to put interesting legal things up there from time to time. Okay, excellent. David, anything to add? No, when can we expect? Okay, great. When can we expect what Doctors.tell you to be off the shelves in Sainsbury's then? Seems like a sort of question I won't be answering publicly. Fair enough then. Okay. Well,
all that remains is to say goodbye for now. This has been episode 58 of the Skeptic Canary Show. I've been Tom Williamson from skepticcanary.com. It's goodbye from me, and it's goodbye from David Jones.
Goodbye.
And it's goodbye from him.
Absolutely. It's goodbye from our guest this evening, Helen Dale. Good night, everyone.
Good night, everyone.